Play. So thank you all again for joining us today. Really glad to be together here with all of you after Friday's really terrible Supreme Court decision ending the constitutional right to abortion in the United States. For those of you who don't know me, my name is Rebecca Harrington. I'm the Senior Director of Advocacy and Outreach for Population Connection and Population Connection Action Fund. And even though things feel really awful right now, that's how we've all been feeling, and I'm sure how all of you have been feeling. We here are really encouraged by all of you and by all of our supporters, and are really energized by the idea of working closely together with all of you over the coming months to fight back against this decision, to stand up for abortion rights in this country, and to do whatever we can to help people access the care that they deserve and that they need and that people want. And I'm also really happy to be joined today by Dara Purvis, who is the chair of Population Connection Action Fund's board. She's also a law professor at Penn State Law, and is an expert on all things domestic reproductive rights policy and law. And she's really a wonderful colleague to be in this fight with. Dara she always says yes to joining us, no matter how last minute or what time of day, even though she has lots of things going on. And even when the content she has to share, like it will be today, will be kind of heavy and hard, always leaves me feeling inspired and empowered that there's something I can do. So we'll have Dara's going to share some stuff with us, help us debrief what happened with the Dobbs decision last week for a little while, and then we'll leave some time for Q&A. And then at the end, we'll share a couple of immediate actions y'all can take to start fighting back against the impact of this decision. So with that, I'll turn it over to Dara.
Thanks so much. And it is not a fun time for those of us who care about reproductive rights, but it certainly makes me feel better to talk about it with like-minded people and talk about what we can do. So apologies, for the being the bearer of bad news as I explain this decision further, but hopefully we can come away with some ideas of constructive things that we can do to keep fighting. So I'm going to have just some slides. It's pretty much just pulling language from the opinion. So you're not just staring at my face as I describe it. But my hope is to kind of walk us through just the reasoning of the opinion and the immediate implications of the opinion. All right, so let's see if I can get my controls on the screen. There we go. So just to introduce where we're coming from, Planned Parenthood v. Casey from about 30 years ago now laid out the standard that the court has been using since then to evaluate challenges to laws that restrict or even prohibit access to abortion. And the basic structure of this was the court from Roe has used the line of viability to say after a fetus is viable, the state has much more authority to restrict or even ban abortion. But pre-viability, Casey created this undue standard. And so it was saying the right to privacy, fundamental right coming from the Constitution, protects the abortion right. But it's not absolute. You don't just say something is a fundamental right and then the analysis is done. The state can do things that restricts or limits access to a fundamental right. It's just harder for the state to do. There needs to be a better justification for it. So the test created in Casey was an undue burden. Does the restriction in question, the statute, the regulation, whatever it is, place an undue burden or a substantial obstacle in the place of someone who is seeking to terminate a pregnancy? So obviously that's overturned. So Dobbs was released on Friday morning. Justice Alito's opinion for the court, his first draft of his opinion for the court, was leaked in early May. So we have known the structure of what this was going to look like since then, but it was not official until Friday. The operative parts of his opinion have not changed much. So most of the edits to the opinion, or most of the changes to the leaked draft, were sections that were added after some concurrences and the dissent were circulated to just respond to those opinions. So there's not a lot of really surprising stuff since we had the kind of advantage of seeing this leaked draft and knowing it was coming. So most obviously, the opinion overrules Roe v. Wade and Casey explicitly. Justice Alito pulls no punches in his condemnation of Roe and really of both decisions, and all of the justices in the majorities of those decisions. He criticizes them very explicitly, calls Roe an abuse of judicial authority, says that Roe was egregiously wrong from the start, says that the legal reasoning in these decisions was terrible. So it is not simply saying, you know, we now understand something different about abortion, or we have changed our minds. It's, you know, these were wrong and stupid when they were decided, and so I'm going to overturn them now, along with obviously the 4 other justices that make this the majority opinion. So one thing that I want to flag before I get into the basic holding of the case and the implications for that, Alito briefly mentions and rejects what might seem like an obvious argument or something that the court should consider to everyone on this call, which is that we've traditionally thought, at least in a constitutional sense, of abortion as part of the right to privacy. But another justification for an abortion right is to make women full and equal citizens by giving them bodily autonomy. Almost all of our equal protection cases developing the principle that the Equal Protection Clause of the 14th Amendment applies to sex and gender came after Roe v. Wade. And in fact, Justice Blackmun, who wrote Roe, later wrote a concurrence in another abortion case talking about abortion as necessary for gender equality. But Alito rejects this by disingenuously saying Roe and Casey didn't address it. We certainly know why they didn't address it, because when Roe was decided, there wasn't this precedent, and says pregnancy does not implicate women's equality. And I'll place an asterisk there and note it is not just women who can become pregnant. Probably in the eyes of Justice Alito, he is, I would bet money that he is transphobic and would not recognize pregnant people who are not women. So the court's language is very gendered in that way, first of all. So especially when I'm putting it on screen and talking about it, you know, it's going to be very gendered language. But also, as I think everyone here can recognize, we can hold both propositions that it's not just women who can become pregnant, but also the view of pregnancy as part of a woman's sort of natural destiny, that we all have a maternal instinct, and all of the rhetoric that comes along with anti-abortion activism is also very gendered and implicates gender equality. But I just wanted to acknowledge that and not make you think I was saying that only women can become pregnant. So anyway, so Alito just says, oh, there's no question of gender equality here because we didn't talk about it in the prior decisions. And similarly, and here I'm pulling language from a bit later in the opinion, if the Supreme Court is considering whether to overturn past precedent, one of the things that the court is supposed to evaluate is whether people have come to rely on that past precedent. So the idea is just how disruptive is this going to be? How much of a change in people's everyday lives will reversing this precedent or this case have? And in Planned Parenthood v. Casey, as this section of the opinion acknowledges, the court recognized that people have had decades to plan their lives both their personal lives, choices about whether and when to be parents, and their work lives, assuming that if they became pregnant and didn't want to be, they could access abortion. So today's court absolutely rejects that this is even the kind of reliance that the court should care about. So at the bottom of this excerpt, the court says the reliance that we're talking about is very concrete reliance interests, like those that develop in cases involving property and contract rights. So this court only cares about reliance if it's economic, if it's contractual, if it's about property. This court rejects the idea that we should even care about the reliance that people, and particularly women, have placed on having control over their reproductive lives. And one of the reasons that the court is so willing to completely dismiss women and people who can become pregnant is because of a historical or claimed historical perspective. So when Alito begins describing the right to privacy and saying, is this part of our fundamental right to liberty? He says, the court majority is only interested in what the framers of the 14th Amendment thought liberty meant. So this would have been 1868. What did liberty mean? So the idea is the 14th Amendment doesn't explicitly say there is a right to abortion. Instead, it says the state cannot deprive people of liberty without due process of law. So the legal question is, what does liberty mean? What rights fit under that? The majority answers by saying only rights that have always been protected are fundamental. So if we can show that something was not historically protected, so for example, if we can show that it was criminalized or prohibited or not respected under the law, then it must not be a fundamental right. Alito's opinion claims that abortion was near universally criminalized. Now, his historical record is wrong, and the dissent points this out. They say when you say that abortion was always against the law, you are not accurately describing that. It was not. Pre-viability abortion was widely permitted under the law. But Alito is pointing to his kind of cherry-picked and very one-sided analysis of the historical record to say abortion was not sufficiently legal historically, so therefore it is not a fundamental right. And that, in the majority's opinion, takes abortion out of the realm of constitutional rights. So the section that I have excerpted here is the portion of the opinion that tells lower courts how to analyze challenges to abortion bans going forward in the future. And I want to point out a few important things. So first, this changes the constitutional standard. So remember from that first slide, previously Casey had established this undue burden test. It's what we would call a heightened constitutional standard. It's something that receives kind of extra protection under the Constitution. This removes that. So laws that regulate abortion are entitled to a strong presumption of validity, and lays out what's known as the rational basis review or rational basis level of scrutiny. So a law must be sustained if there's a rational basis on which the legislature could have thought it would serve legitimate state interests. This is the lowest level of constitutional scrutiny. This means that a person challenging a law restricting abortion in the future must prove that the law has no rational relationship to a legitimate government goal. Obviously, that's incredibly difficult to do. But the other thing I want to point out is that Alito not only says, okay, use this lowest standard of review, you get no constitutional protection for this right, but he then goes on to provide an answer by listing possible or available legitimate state interests. So from my professor perspective, this is like if I said, oh, there will be a test next week. If you write 14th Amendment on your test, I will give you an A. He is giving both courts and legislators passing these laws in the future the justification to make sure that the law will be deemed constitutional. So this list that he gives is incredibly broad, and it tips Alito's hand as coming from a pro-life, very anti-abortion perspective. So he says these legitimate interests include, starts out with respect for and preservation of prenatal life at all stages of development. That's incredibly far-reaching. And to begin to think about some broader implications that I'll mention in just a few minutes, I can think of all sorts of regulations on pregnant people, or even people who just could become pregnant in the future, that could be justified by saying, well, we're trying to indicate respect for and preservation of prenatal life at all stages of development. Then he says the elimination of particularly gruesome or barbaric medical procedures. This is kind of a throwback to some of the court's past opinions, where, for example, in a case called Gonzalez v. Carhart, in that decision written by Justice Kennedy, he describes the mechanism, just literally what happens during a late-term abortion, in great detail, because he likely knew that it would just kind of gross out the average reader, and they would think of this medical procedure as something that they should feel disgust or revulsion or feel uncomfortable about. But frankly, that's true probably of most medical procedures. If I were to start giving an incredibly detailed rendition of what happened during my C-sections, many of you would probably be kind of grossed out. I would probably be grossed out. It's why they put a curtain in front of you. Like, unless you're a surgeon, we don't typically like thinking about the nuts and bolts of medical procedures. But putting it in there, it implies that there's something worse about abortion, that there's something more barbaric about abortion than there is about all sorts of other medical procedures that we regard as totally neutral and just run-of-the-mill healthcare. Then he says the preservation of the integrity of the medical profession. Again, this is coming from a really pro-life perspective. This is underscoring the idea that doctors who perform abortions demean the medical profession, that they're doing something to take away from the respect that we feel for healthcare providers. The mitigation of fetal pain, to my mind, is the biggest tell. This is just straight up pro-life propaganda. If you talk to doctors who look into fetal development, there is widespread consensus that it is not until the very late stages of pregnancy that there are even nerve mechanisms that we could describe as, creating and transmitting what we would think of as pain. The idea that early abortions, first trimester abortions, which are the vast majority of abortions performed, involve anything that resembles fetal pain is just pure talking points from anti-abortion activists. And then this last one, the prevention of discrimination on the basis of race, sex, or disability. This is referencing some anti-abortion tactics to say, well, even if you do have a right to abortion, you can't terminate a pregnancy because, for example, you find out that the fetus will have a genetic abnormality. It's a way to dress up restrictions on abortion by saying, here is an inappropriate reason for someone to choose to terminate their pregnancy. Putting it in the list of justifications here just underscores this idea that people who previously were able to access abortion were doing it for the quote unquote wrong reasons. So again, this test, number one, permits basically all restrictions and bans on abortion. 2, Alito gives legislatures a laundry list that they can just copy and paste this list, put it in the preamble of a statute, and it will presumptively give that clear constitutional justification. And 3, it really demonstrates the pro-life perspective that the majority of the Supreme Court is taking. So then finally, pulling from the opinion, the last point I want to make using the text is an implication for broader consequences. So this language is from Justice Thomas's concurrence, so he is writing only for himself, but he says, after saying he agrees with the criticism of the right to privacy expressed by the majority, In future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Griswold started the constitutional right to privacy. It was having to do with access to contraceptives. It struck down a Connecticut law that said that it was illegal to access birth control. Lawrence struck down Texas's law that said it is a criminally prohibited for same-sex couples to have sex. We will throw you in jail for being gay. And Obergefell established marriage equality for same-sex couples, said it is unconstitutional for states to only allow different sex couples to get married. Now, so Thomas is saying we should reverse all of those as well. The logic of today should extend to all of these past precedents. Alito does say, no, this is different because this is about potential life. So this is about the life of an unborn human being. This is about potential life. So don't worry about those other precedents. But none of his legal analysis rests on potential life. His legal analysis, as I described it, is about what was historically protected. We are only going to protect these fundamental rights. And we're not going to extend them to things that were historically against the law. Contraceptives were historically against the law. Premarital sex, extramarital sex were historically crimes. Discrimination against LGBTQ people obviously has a very long history. So there is no reason why the majority's analysis would not apply in exactly the same way against the cases that Thomas lists. And I think we should all be really concerned, especially given all of the cases that the Supreme Court has issued in the past week, that they are enacting the preferences that they choose. And I absolutely do not believe Alito's attempt at limiting the implications of this case. So to talk a little bit about what is happening now, I pulled this graphic from the New York Times website earlier today because the field is the ground is changing so quickly, just to show what's happening to abortion access. This really is changing day by day. But so there are some states in which laws prohibiting abortion have already taken effect. On the left, the likely to be prohibited or restricted are states generally where they're either in the process of passing or they have newer laws prohibiting or strictly restricting abortion. That often means a 6-week ban, which is virtually all abortion. It's unusual for people to know that they are pregnant very long before 6 weeks. Plenty of people find out long after 6 weeks. And then on the right are states where it's really still up for the political process. I'm in Pennsylvania. We have a state legislature that keeps trying to pass anti-abortion laws, and the governor keeps vetoing them. We have an election for our new governor in the fall. So basically, who wins the governor's race in Pennsylvania is going to decide whether Pennsylvania has abortion access at all. And the states that are restricting abortion are using creative ways and thinking about different ways to try to prevent access to abortion, even by people crossing state lines and going into states where abortion is still legal. No state has actually passed a law saying you can't cross state lines to access abortion yet, but it does seem likely that they're going to try, and that's going to be a legal issue that will have to be fought out in court. Another question that is coming to the forefront has to do with medication abortions. The majority of abortions in the US since 2020 are performed with medication. They're not surgical procedures for the most part. And the FDA allows for mifepristone to be prescribed through telemedicine and sent through the mail. You don't have to physically go into a doctor's office to get it, at least according to the FDA. Anti-abortion states are trying to limit how mifepristone can be accessed. Things like passing laws saying that you can't take it on your own. A clinician has to be physically present to give someone the drugs. this is going to continue to be an ongoing legal issue. States are going to try to restrict access to medication abortion, and potentially there's some indication that the federal government is going to be defending that right. Attorney General Garland sort of underscored the FDA allows this. States do not have the ability, to sort of supersede the FDA. But I also want to make clear, striking down abortion as a constitutional right is seen and described in the majority's opinion as throwing the issue to the states. So now state legislatures will decide, but it also opens the field for national political action. And Mike Pence, among many others, is already saying we should have a national ban on abortion. And certainly, if Republicans are in charge of Congress and either have a veto-proof majority or if they win the presidency, that will happen. We will have a national abortion ban. There's also, in a longer term, the possibility that the Supreme Court could, in theory, find a fundamental right to prenatal life. They could say liberty extends to fetuses. And I do think that's a viable possibility. I think it's quite likely, frankly, that a majority of this court would agree with that. So obviously, access to abortion has been incredibly limited. We are seeing effects not just literally, obviously, in abortion access, but in treatment for all sorts of reproductive related conditions. So abortion prohibitions are already harming care for things like miscarriages and ectopic pregnancies, because the way that you treat a miscarriage that has started spontaneously, or a way that you treat an ectopic pregnancy, is to, basically to perform an abortion, whether that's giving someone who has an ectopic pregnancy medication that will trigger the end of the pregnancy, or whether someone who is going through a miscarriage, you need to have a surgical procedure to make sure that all of the miscarriage-related tissue has exited their uterus. The care looks like abortion. In some ways, it is abortion. And we are already seeing reports of people presenting with medical emergencies at physicians' offices and at hospitals, and doctors and pharmacists and nurses, either who agree with abortion bans or who are scared of the liability, are not providing that care. And then to end with a shameless self-reference, this opens the door to regulation of pregnant people significantly. We already have significant regulation and even criminalization of pregnant people, particularly non-white pregnant people and poor people, in the name of protecting the viability of pregnancies. With the door open to these abortion bans, we are going to see a lot more of this. We're going to see a lot more legal regulation of some of the most vulnerable people and their reproductive rights. So this is why I say my presentation is not going to make anyone feel better, because this is not a narrow opinion. This is, in a lot of ways, kind of the worst case scenario. Alito is extremely anti-choice. He has been through his entire judicial career, and it does not seem like the other members of the majority kind of mitigated his arguments or made him write a bit more narrowly than he would have otherwise chosen to do. So this is going to have just stunning implications, both in the near term and the long term. And it's really important that we stay as motivated as we can, that we continue fighting this, because this is a big change, and there's a lot that we can do to fight against it. But it's going to be a lot of work. So thank you so much. I'm happy. I think I missed at least one question in the chat while I was talking, but I'm not sure if I should go to questions yet, or I know that there's some specific suggestions for some of the actions that you can be taking now. So I will pause there and see what I should, whether I should keep rambling or not.
Grace, do you want to moderate questions?
Oh yeah, of course. Sorry, I didn't know whether Yasmin wanted to jump right in with the actions. Well, thank you again, Dara. We so appreciate it. It has been very elucidating, at least for me. I know this was like a really horrible opinion to read through, so I appreciate the sacrifice. We do have a couple of questions in the chat, and then I'm going to ask people if you have any further questions, please unmute. All I ask is that for the sake of time, please keep your question as brief as possible so we can get everybody's in and then go into actions that you can take. So the first question is from Yasmin, and it is about if Thomas's, going by Thomas's logic, that a lot of those other court cases should be struck down. Why does that not extend to Loving, which was the court case that allowed for interracial marriage?
Yeah, Loving v. Virginia, yeah, struck down Virginia's law prohibiting, we use the shorthand, you're right to say interracial marriage, but it was really just white supremacy. It said only white people can marry white people and everybody else can have their own marriages. So it does not extend to Loving because Loving had two different grounds for its holding. So Loving both rested on a fundamental right to marry, which you could imagine being vulnerable here. So it's a fundamental right in the same way that the fundamental right to privacy has been talked about. But it also rested on the Equal Protection Clause, and the majority of the court's decision in Loving talks about the Equal Protection Clause, says Virginia's law is clearly racist. It's clearly about perpetuating white supremacy, and the Equal Protection Clause tells us that the government cannot take this kind of racist action, at least as explicitly as it did there. I have many thoughts about racist actions by the government, as I'm sure many of you do, but it has a separate kind of leg of analysis that Dobbs does not touch, because Dobbs, as I talked about, Alito just says there's no equal protection sort of analysis here. So Loving v. Virginia has a totally separate reason that it won't be affected, but the privacy aspect, in theory, the fundamental right to marry could be.
All right. And then Alex would like to know, given that this opinion has kind of exposed the court as a totally political institution versus what we were supposed to believe beforehand, whether or not you actually believe that, your mileage may vary. How can we continue to trust the Supreme Court when it's very legitimately is based on public trust?
Yeah, you can't, is my opinion. And I say that as someone who teaches about the courts and, would really love to believe that there is something like neutral principles. So Chief Justice Roberts in his confirmation hearings famously said that the job of a judge is calling balls and strikes. We have like some neutral principles, we have some neutral rules, and all that judges are called upon to do is look at the rule book, look at the law in question, and assess them from an objective point of view against each other. I don't think that you can say that this Supreme Court is doing that with a straight face. In my opinion, certainly the last week, but really much longer than that, but just that we have egregious examples in the last week of the majority of the Supreme Court is enacting their own policy and ideological preferences dressed up in legal rhetoric. And it's conservative. It's Christian nationalist principles and ideological goals. There is no way that I can think of to make these cases from the last week even consistent with each other, let alone with an idea that the law is neutral. So I think the public is beginning to see that to some extent. One of my colleagues at Penn State, who's a political scientist, has been saying we shouldn't say that the court is illegitimate, because if it was truly illegitimate, people would just be refusing to comply with what the court is saying, and we don't see that. And that is obviously true. Like courts and states, and for the most part, law enforcement seem to be complying with what the court said. There is some possibility, or there are some indications that that may crumble a little bit. There have been a number of district attorneys throughout the country, particularly in larger cities in conservative states, who have said, I will not prosecute people under this law. And that's kind of a form of civil disobedience, although it is within prosecutorial discretion to decide what cases to bring. I think that's beginning to show a little bit of sort of a true crisis of legitimacy. But in my opinion, I think this court is just sort of fatally flawed. I don't see how you come back from this. Another law professor at Michigan, Leah Littman, has called this the YOLO court, because it's just 5, arguably 6, really conservative justices who realize they have the numbers, even if public opinion is very much not with them, and they're just trying to push as much through as far as they can get it while they have the chance. I think that's what's happening. In my mind, I don't think my view of this court will change either until the membership significantly changes, or I guess this falls under the membership completely changing. I wish that that Biden was talking about expanding the court. Because to my mind, there is a legitimacy crisis here, and I don't think it's going to be fixed with the current membership.
Wow, thank you for that. I think that's kind of what we needed to hear right now. So Dee Lawson just wanted to confirm, is contraception potentially in jeopardy as well as abortion?
I think it is. That's a medium to longer term issue. So nothing that the court said in Dobbs is going to make police or legislatures in different states confident that they can ban contraceptives. But what I would be worried about is kind of twofold. In the short term, there are some birth control methods that anti-abortion activists argue could cause abortion. For the most part, it's not accurate. So for example, the morning after pill mostly works to prevent implantation of a fertilized egg. I will note that some anti-abortion states are trying to define life as beginning at fertilization, which Dobbs leaves them open to do. But for the most part, people define the start of pregnancy as implantation. When the morning after pill or Plan B was being proposed to the FDA, they were trying to describe the mechanisms pretty broadly. So they said, in theory, this might be able to prevent, sort of go further and like disturb an existing pregnancy. There's no real indication it does. But anti-abortion forces have really done a lot of work to say, Plan B, even birth control pills, even things like IUDs could potentially cause someone to miscarry, basically. And so if they are saying this actually does cause abortion, we want to ban any contraceptive method that could cause abortion, I think that is in the kind of short term a possibility. In the longer term, it's Justice Thomas's version, which is, I want to overturn Griswold and similarly leave open to the states whether they can ban just contraceptive access entirely, contraceptive access to unmarried people, and so on. So the broader version is more long-term, and I think that's a viable possibility as well. And we may see increased regulation or bans of what contraceptive methods are available to people in the short term.
All right. Marian would like to ask if you could explain John Roberts' opinion on this decision specifically.
Yeah, so Chief Justice Roberts, he wrote a concurrence in the judgment, which means he agrees with the result of the case, but he does not sign on to all of the court's analysis. And his concurrence is pretty predictable based on what he did at oral argument. He was pretty clearly trying to say we could remove the logic from Planned Parenthood v. Casey. We could say we're not going to use the undue burden standard anymore. We're not going to use the viability line anymore because I think that these no longer make sense in today's world. And we could say that the Mississippi law in question, which bans all abortion after 15 weeks of pregnancy, we could say that this statute is constitutional, but we don't have to go so far as to actually overturn Roe and Casey. We can just say, we're changing the standard, and now it's a really low standard, and we'll kind of figure out how low it can go later. This is perhaps the only part of Alito's opinion that I agree with, where he criticizes the Roberts approach and says, we still end up at this point in the future. Like, that's not a long-term solution to what happens. If you remove any kind of heightened constitutional protection and say that a 15-week ban is fine, next term we're going to have the 6-week bans, or we're going to have a 10-week ban, or, we'll just keep having this argument, and we'll keep having these cases. So I suspect that's why he couldn't get anyone from the majority to join him. I also suspect that this is one reason that the opinion was leaked early, to prevent anyone from going over to join Chief Justice Roberts in that opinion. He was trying to cast it as kind of a compromise, a moderate position. In some ways that's accurate. In some ways it would have given more time to potentially have a change in membership in the court. But I think we probably would have ended up in the same place with, Roe being overturned in 2 years from now until today.
All right. Could you also go a little into the official justification for expanding the court? And they specifically cited that some people are saying 13 justices for 13 district courts.
Yeah, so the size of the Supreme Court is not in the Constitution. It's just statute. And so the last time that the membership numbers of the court was changed, they expanded the court slightly to say, well, we have 9 appellate circuits. So we should have 9 Supreme Court justices. And so people today are saying, well, why can't we just match it? There are now 13 appellate circuits. So why don't we have 13 justices? Let's add 4. I think that's fine as a hook for the number of justices, but it really is something that is just kind of up to Congress. There's nothing kind of magic about the 9 justice number.
All right. And you spoke about a potential national ban on abortion. What would have to happen to enact that, and how far out is that threat in your personal opinion?
So it could just happen as a matter of just regular law. So this would just be, can this law get through Congress? The federal government has banned sort of aspects of abortion in the past. Gonzalez v. Carhart, the case I mentioned earlier, where Justice Kennedy started his opinion by describing a late-term abortion in great detail, was banning a specific procedure, a way that late-term abortions were performed. There's a lot of action about how abortions are funded or not funded, how they interact with international aid, and so on. So it literally would just mean a House of Representatives and a Senate with enough Republicans, and there are still some anti-choice Democrats who were willing to pass a national ban, and a president who was willing to sign it. So as you can imagine, we are not that far from that possibility. Because of the way that districts are gerrymandered, and because of the way that incumbency operates, it is expected that Republicans will take the House of Representatives in the midterms unless we work really hard against that norm. The Senate is kind of half and half right now. So flip it just a little bit further, and Republicans could have the majority. And I will note, Republicans would absolutely get rid of the filibuster to pass a national abortion ban. Like, the filibuster, the second Republicans are in the majority and want to do something, they will get rid of the filibuster. So we are, potentially close to that possibility. We are also potentially close to the possibility of a national law codifying the abortion right. So if Democrats, I'm very partisan, apologies. If Democrats hold the House of Representatives and get 2 more seats in the Senate, they could pass a law that said abortion is legal nationwide. Now, what the Supreme Court will do after that, all bets are off. But I know that it's frustrating. I saw someone say that, like, go vote is the Democrat equivalent of thoughts and prayers, and I do feel that way a lot of the time. But we really are on a knife's edge in terms of political action. So we could have a national ban on abortion very easily. We could have a national right to abortion reasonably easily if we win a few really important seats.
Considering that the opinion like pretty explicitly passed on the right to decide whether or not abortion is legal to the states, can you explain why we have the chance to either have a national ban or a national right to abortion codified, and like what potential challenges that would look like?
Oh, sure. I mean, it would just be federal statute. So frankly, given how many states already had either pre-Roe v. Wade bans on abortion or trigger laws saying the second that Roe v. Wade is overturned or 30 days after Roe v. Wade is overturned, we're going to ban abortion. I think it's just pure rhetoric to say, oh, we're handing this back to the states. We're handing this back to the people. I mean, I should also say, we don't have, a representative political system in the sense that people do not have equal access to the ballot box. People do not have equal voice in our government. So I also just find it incredibly disingenuous to act like, oh, we're handing the position back to the people. People in Texas did not get to vote. They had gerrymandered districts. They had very unequal access to elections. You have states suppressing the vote, particularly suppressing the vote of non-white people. It is not accurate to say, yes, we'll just hand this back to the people and the people can decide. Many states had laws from decades ago telling people what they had already decided. And in addition, so I just think it's not accurate. It's just a rhetorical flourish to say we're handing it back to the states. They weren't. They were handing the decision back to laws that were passed decades ago. And Alito knows that, and the majority of the court knows that.
I also wanted to ask, and Marian as well, given that there are like 3 nominees to the court that said under oath that they would respect president, yada, 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 is there like really any recourse for the fact that they lied under oath?
No, other than angrily tweeting at Susan Collins and saying, I have a bridge that I would like to sell you. I mean, it's incredibly frustrating because really all of the members of the majority said, oh, Roe v. Wade is settled law, Roe v. Wade is precedent. It's only precedent until it's not. It's only precedent until the court decides to reverse it. And in presentations on the leaked draft, I had this text, I took it out for today, but Alito's opinion says, oh, we really respect precedent unless it's really bad. For example, Brown v. Board of Education reversed Plessy versus Ferguson and said that racial segregation was unconstitutional. So he pretty explicitly compares this decision to Brown v. Board of Education, probably the most famous racial justice decision that the court has ever issued. And I think these members of the court truly do view that as the stature of this decision, that they think they're doing a super great thing. So, I mean, I'm frustrated by it. I think it exposes kind of the, pointlessness in a lot of ways of the hearings with Supreme Court justices, because they'll say what they need to say. I think we all knew in the moment when they were answering those questions, there is no way that these people don't have opinions on abortion. But all that it's done is tell people who want to be judges, don't say something publicly about abortion until you're in a life tenured position.
Well, thank you so much for answering all of these questions, Dara. We so appreciated having you here. I did want to make sure that we had enough time for one more question to Yasmin, which is, where do we go from here and what can we be done to fight back?
Awesome. Thank you. And thank you again, Dara, for sharing your wisdom as Grace said, reading through that opinion and explaining it to us, I'm walking away feeling really angry, but not disheartened. Like there is so much that we can and have to be doing in order to fight back against this. So here at Population Connection Action Fund, we have a few actions that you all can take immediately, and not only take, but share with everyone in your networks, friends, family, anyone who you know who cares about abortion access to reproductive rights, and all of these follow-on things that Dara mentioned. Now really is the moment to it's always been the moment to dig our heels in, but
as Dara said, we're kind of on a razor's edge, and I think it's important that we take that seriously. So the first action that we are going to be sharing with you in the chat is we have created a pledge to become an abortion defender with Population Connection Action Fund. As Dara said, this landscape is ever evolving and is going to need new tactics, new folks. We're going to be keeping you apprised of everything you can take now through Election Day. So you'll be joining a group of committed reproductive rights activists. We're going to stand up to speak out for abortion rights for all Americans. Some of the actions we'll take will include phone banking, attending trainings, sharing petitions, contacting your legislators, and importantly, but not only, voting. So signing up to become an abortion defender means we will keep you very much in the loop as everything evolves, so that you can be taking as many and the most impactful actions you can through the rest of the year and beyond. So the link has been shared in the chat, and we will be sending a follow-up email to everyone who attended today, not only with the recording, but also with these actions. So don't worry if you're on your phone and you can't access the chat right now. The second, and actually this has kind of been a little bit of the focus of the questions that have been put to Dara today, is how can we create the ability for federal abortion legally everywhere? And that is through legislative action, meaning passing that into law. And there is a law that passed the House. It just had a vote in the Senate. It didn't pass that, but we need to make sure it passes, called the Women's Health Protection Act. And so we have a form where you can fill out and email your senators asking that they vote yes on the Women's Health Protection Act, which would make abortion legal for everyone in the United States. Excuse me, it is a bill. It is not yet a law. We need it to be a law so that everyone's abortion rights are protected here in the United States. So if you follow that link, and again, we will be sending this out afterwards to everyone who signed up for this call. It is a very simple form where you fill in your information and it will automatically send an email to both of your senators for you, urging them to vote yes on this really, really important bill. And like I said, we will be monitoring the situation and making sure that all of the most timely tactics and actions are hitting your inbox. So if you're not already, you can sign up with the Abortion Defender form or on our website, and we'll keep you up to date. And again, I want to thank all of you for coming here today. I know it's a really heavy time, and so taking time out of your day to really dig into what the decision means can be really, really heavy. But I'm so inspired to be in the virtual room with all of you, knowing that we are scattered across the country, but really, really committed to ensuring that fundamental human rights are upheld for everyone. So I'll pause there and see if anyone has any questions about the actions. But otherwise, I really want to thank you all for joining us today, and a huge thanks to Dara for taking time out of your busy schedule to enlighten us with everything that's happened thus far. So thank you all and have a wonderful day.
We've got one more question in there if we want to ask it.
Is this the cinema and mansion?
Yeah.
Rebecca, do you want to answer that?
Sure. And then Brian, if you're on, you can jump in to add or correct me. But I believe Sinema, when it was up last up for a vote in May, Senator Sinema did vote for it, but Senator Manchin did not. So yes.
And I will add that even if your senator voted the first time around, it's important to give them a nudge. We want them to know that we're watching and that we care, and that they will be taken to task if they're not voting to uphold abortion rights and reproductive rights overall. So I would encourage you to fill out the form, even if both of your senators voted for WIPA, or the Women's Health Protection Act, the first time around. It's really important that we show support and that they know where their constituents land on the issues. So again, thank you so much, everyone. Really amazing to be in community with you, and we will continue to take actions together to push back against this egregious decision. And until then, have a wonderful day.